Throughout the 17th and 18th centuries, people were brutally kidnapped from Africa and forced into slavery in the American colonies. By the mid-19th century, however, the United States was fiercely disunited over the practice of slavery. The southern states built their entire economy on the exploitation of people as slaves, whereas the northern states had abolished the practice as a contradiction to the right of every human to be free. This friction led to the Civil War of 1861. But just 4 years shy of the war, and just 8 years before slavery was permanently abolished throughout the United States, a Massachusetts court faced a slavery case with an unusual twist. The defendants were a white couple, Lewis and Laura Sweet, who lived in Nashville, Tennessee, where slavery was still legal and prevalent. During their travels, the Sweets were in the habit of taking along their black slave, a lady by the name of Betty. In 1857, the Sweets toured Canada and various northern states, but when they arrived in Lawrence, a city in the abolitionist state of Massachusetts, they ran into trouble. Local anti-slavery activists recoiled at the sight of a woman of color accompanying her white master and mistress. They demanded that the Sweets set Betty free. The couple claimed that they would not retain Betty against her will, but that Betty was not seeking her freedom. The activists then turned to Betty. They begged her to assert her rights and to refuse to return to Tennessee with the Sweets, but Betty brushed them away. One Lawrence activist, a widow named Lucy Schuyler, petitioned the Boston courts to intervene. The case, referred to simply as Betty's case, was heard by Massachusetts Chief Justice Lemuel Shaw, a deep thinker with considerable influence on the development of American law. Shaw requested the parties' consent to interview Betty in private. He reported,
I proposed and had an examination of the said Betty, apart from the said Sweet and wife, and all other persons, upon which it appeared to me that she is 25 years old, intelligent, and capable of judging for herself, that she has a husband in Tennessee and other relatives, that she is much attached to Mr. and Mrs. Sweet, is very well treated by them, and desires to remain and return with them. And this desire she expressed decisively, and upon repeated inquiries. I explained to her her right to freedom and protection here, and that she could not lawfully be taken away against her will.
The judge found himself in a quandary. Under the laws of his state, slavery was illegal and wrong. On the other hand, Betty insisted that she wished to remain with her masters. Betty's freedom appeared to be pitted against her free choice. Judge Shaw opted for the free choice argument.
It was contrary to all the principles of freedom that this or any other person should not exercise a free choice in such a matter. Betty was entirely at liberty to exercise her free choice, and no one could interfere with her without incurring a personal liability. Wherefore it was ordered and adjudged that the said Betty be at free liberty to remain with Mr. and Mrs. Sweet, or go elsewhere at her free choice, and that all persons be interdicted and forbidden to interfere with her personal liberty in this respect.
The underlying dilemma of Betty's case rings louder and lingers longer than an individual judge's decision. Should an individual be free to choose to be a slave?